Okay, let's unpack this. We're diving deep today into a legal saga out of Australia that is absolutely packed with drama.
Oh, definitely.
Think unexpected twists, intense battles over the most technical legal rules, and some absolutely crucial lessons for anyone navigating the world of business, especially when ambitions collide with financial reality.
That's right. While this story involves the often complex and, let's face it, sometimes dense world of corporate insolvency, it's far from just a dry recitation of statutes.
No, not at all.
At its heart, it's a human story of ambition, the immense strain of financial pressure, and a tenacious fight for accountability when a venture collapses and creditors are left holding the bag.
Exactly. Our deep dive today centers around the unraveling of a property development venture and the, well, years-long legal fallout that followed. The ultimate fight wasn't just about recovering money. It was about defining who was really in charge, what their duties were, and holding them responsible for the collapse.
Right.
We're focusing particularly on a series of significant judgments from the Supreme Court of New South Wales that mapped this whole thing out, with a special focus on one key procedural ruling, now referenced as 114 NSWLR 77, that became a pivotal point in clarifying how liquidators can even present their case in court.
Yeah, that one's pretty key. We've been poring over the core sources for this deep dive, the key court judgments themselves, specifically 2024 NSWSC 547, 2024 NSWSC 735, and 2024 NSWSC 421. We've also looked at legal commentary surrounding these decisions. These documents together give us a really detailed picture of the dramatic procedural skirmishes and the substantive legal battle waged by the liquidator on behalf of the company's creditors.
So our mission is clear. We're going to guide you through this complex story. We'll cut through the legal jargon, introduce you to the key players, think of them as our dramatis personae, and highlight the most important insights and surprising facts buried in these rulings. And crucially, we'll show you how this saga has left a tangible mark on Australian legal practice, particularly for anyone involved in insolvency or indeed anyone who holds a directorial position, formal or otherwise. Get ready for some genuine aha moments.
Let's set the scene for how this all began.
Right, the setup. Every big business saga often starts with grand plans, and that was certainly the case here. The dream belonged to a group of entities collectively known as Alora Davies.
Right.
Their ambition was firmly set on property development, specifically targeting growth areas in the Wollondilly Shire Council, southwest of Sydney, places like Thirlmere and Talmore.
And in the early days, there were signs that this group, well, they knew how to navigate the often tricky world of planning and regulatory hurdles. When their development applications ran into issues with the council, the Alora Davies entities didn't shy away from taking the matters to the Land and Environment Court.
They did indeed. Take the Thirlmere project first, handled by Alora Davies 103 Ltd. When faced with council objections, they launched a Class 1 appeal in the Land and Environment Court. But interestingly, rather than pushing straight to a full contested hearing, the court directed them to conciliation conferences.
Ah, right. Those conferences were held on 14 February and 20 March 2018 with Commissioner Dixon presiding, and they proved successful. Alora Davies 103 and the council reached an agreement, which was then formalized under Section 34 of the Land and Environment Court Act 1979.
And this agreement paved the way. The development application was amended, revised plans were submitted based on the conciliation outcome, and approval was eventually granted on 4 May 2018, subject to conditions.
But it's crucial to note, as the commissioner did, that because this was a negotiated outcome via conciliation, no merit assessment was actually performed on the original reasons for refusal.
Okay. So it wasn't like they won on the merits, they just struck a deal.
Exactly. It was purely a deal struck between the parties.
Interesting. And we see the legal teams involved in navigating this phase.
Yeah, swab attorneys with Counsel C. Rose represented Alora Davies 103, while Marsden's law group with Counsel D. Baird acted for Wollondilly Shire Council. This process was also linked to an underlying voluntary planning agreement, or VPA, a standard tool where developers contribute to public infrastructure.
Got it. And they followed a similar playbook for the Tamworth development application, managed by Alora Davies 104. That also hit council issues and landed in the Land and Environment Court.
Exactly. For the Tamworth DA, conciliation conferences were held on 10 July and August 2018, this time before Commissioner Bish. And again, conciliation was fruitful, leading to an agreement between Alora Davies 104 and the council to resolve the court proceedings.
And notably, Alora Davies 104 also retained SWAM attorneys for the Tamworth case, with C. McFadzean representing them this time.
That's right.
While RMB lawyers, with J. Bignell, acted for the council. So on the surface, you see a picture of business entities that, while facing regulatory challenges, seemed capable of navigating the legal system to get their projects approved.
Yeah, they had the legal teams, they used the court processes effectively, at least initially, to reach agreements.
But this early ability to get approvals masked a critical underlying problem, particularly for the Tomore project.
Oh, definitely. Despite getting the development green light through conciliation, Alora Davies 104 never actually acquired the land needed for the development to proceed.
They simply didn't have the money to fund the purchase.
Precisely. And this failure to secure the fundamental asset meant the project just stalled.
Yeah.
It couldn't transition from the planning stage to the profitable construction and sales phase.
Right.
The sources describe the Tomore project specifically as becoming a financial black hole. It was burdened by significant loans, like a nearly $480,000 loan from a party named Hammond, which fell due on 17 May 2019.
So this wasn't just a temporary setback. The inability to complete the projects and generate revenue created crushing financial strain.
Absolutely. This strain is the clear thread that pulled Alora Davies Development's 104 Pty Ltd into insolvency. The court later found the company was insolvent from at least that date, 17 May 2019, onwards.
And when a company becomes insolvent and can't pay its debts, that's when a liquidator is appointed to step in and take control.
Which brings us to the players.
Ah, yes, the dramatis personae. Because behind every complex legal case are the people and entities whose decisions and actions ended up being scrutinized.
Absolutely. And in this saga, the court honed in on specific figures whose roles, relationships, and dealings were central to understanding the company's collapse and pursuing recovery.
First up, the second defendant in the main proceedings, Priscilla Elizabeth Raphael, or Mrs. Raphael. She's described as the wife of the first defendant, David Raphael.
Mrs. Raphael proved to be a particularly central and ultimately controversial figure in the court's findings. Her formal roles included being a director of Alora Davies Developments, one of our Peaceful Ltd, from April 2017 until 11 January 2018. Yeah. And also a director of Alora Property Group, Pizza Ltd, APG, during a similar period.
But the absolutely critical finding about her, made by Justice Black in the main judgment,
that's huge,
was that despite formally resigning as a director of Alora Davies 104 in January 2018, she continued acting as a de facto director from the very next day, 12 January 2018, right up until May 2020.
Now, this de facto finding is massive. It means the court found that, in substance, she was still calling the shots at a high level, even without the formal title.
Right, not just an employee.
Exactly. And this finding was key because it exposed her to potential liability for actions like insolvent trading and breaches of duty that occurred long after her name was off the official director register. The sources detail her deep involvement. She was managing the Tomore project, engaging directly with external parties like solicitors, financiers, real estate agents. The court saw evidence she was intimately involved in the company's critical operations.
And Justice Black's judgment also raised serious questions about her credibility, didn't it?
It certainly did. He found her evidence in that main case, NSWSC 547, to be largely unreliable unless it was supported by other sources. He noted inconsistencies in her accounts and a reluctance to recall details when questioned. That lack of credibility significantly impacted her defense.
Makes sense. Next, we have the first defendant, David John Raphael, Mr. Raphael.
Yes. He's Priscilla Raphael's husband and was a statutory director of Alora Davies 104 during relevant periods. He was also a director of MP1, another entity that featured in some of the transactions.
So he faced allegations of insolvent trading and breaches of director's duties right alongside his wife.
He did. While formally a director, the sources seem to focus more on Mrs. Raphael's operational involvement. But he was definitely implicated in the challenged transactions, like the APG payment and the VPA transaction, and the insolvent trading claim based on his formal directorship.
Okay. Then we have the driving force behind the legal action to recover funds. Henry McKenna, the second plaintiff.
Yes, the liquidator appointed to Alora Davies Development's 104 Pty Ltd when it went into liquidation.
His job is the challenging one of picking up the pieces, right? He has to investigate the company's collapse, uncover what happened to its assets, and pursue legal action if necessary to recover funds for the creditors who lost money.
Precisely. He's the one who initiated and pushed forward with these complex recovery proceedings against the Raphaels and APG.
And, as we'll discuss in more detail, His affidavit evidence, based on his statutory investigations as the liquidator, became the specific subject of that crucial procedural ruling we mentioned earlier, NSWSC 335.
That's the one. For the main substantive proceedings and the related applications, Henry McKenna and the company were represented by Pinsent Masons as their solicitors and M. Davis as their counsel.
Okay, Pinsent Masons and M. Davis for the plaintiffs. Got it. Another important player who started out on the other side was Drew Davies.
Ah, yes, Drew Davies. He was initially named as the fourth defendant by the liquidator because he was a director of Alora Davies 104 from January 2019. However, he later settled the claims against him.
Right.
And crucially, after settling, he became a witness for the plaintiffs.
So his position shifted significantly.
Dramatically. His private interview transcript with the liquidator's legal team became the focus of a separate, intense privilege dispute heard in NSW's SC 421.
We'll definitely get into that.
And his evidence was used by the liquidator to support their claims, specifically testifying about key events like Mrs. Raphael referring to that $202,000 APG payment as quarantine money, and being told no money was being exchanged for the VPA rights. His testimony, accepted by the court, contrasted sharply with Mrs. Raphael's account and significantly aided the liquidator's case.
Okay, so he became a key witness against the Raphaels. Finally, the third defendant, Alora Property Group, Pty Ltd, APG.
Yes, this was a related company linked to Alora Developments, Pty Ltd, and the Raphaels. APG wasn't just a defendant, it was also a creditor in the liquidation, having its own proof of debt appeal heard back in 2021.
Right, so involved on multiple fronts.
Exactly. And APG was the key defendant in the liquidator's action because it was the recipient of two significant payments that the liquidator challenged as voidable transactions. Its own liquidation during the proceedings added another layer of legal complexity, requiring the liquidator to get the court's permission to continue the case against it.
So you have the failed company, the liquidator tasked with recovery, the individuals accused of being responsible, one formally, one who the court found was acting like a director even after resigning, a former co-director turned key witness, and a related company that received the funds in question. Quite a cast.
Indeed, a fascinating cast for a legal drama. And getting to the core of this drama involved not just the main trial, but a series of battles fought along the way.
Right. Let's follow the procedural journey, because how you get to the judgment is often as dramatic as the judgment itself. We've set the scene with the initial Land and Environment Court approvals, where Alora Davies entities, represented by firms like Suave Attorneys, Marsden's Law Group, and R&B Lawyers, successfully navigated planning hurdles through conciliation.
But that earlier success couldn't sustain the venture. As we discussed, the Tomore project, handled by Alora Davies 104, hit that fundamental roadblock: the inability to secure funding to actually buy the land.
And that triggered the cascade to insolvency. With the land purchase failing and significant loans, like the Hammond loan, falling due from 17 May 2019, the company couldn't pay its debts.
The court later formally found Alora Davies 104 was insolvent from that date,
which led to the appointment of Henry McKenna as liquidator. His statutory duty is to investigate, take control of assets, or pursue them if they've been improperly transferred, and ultimately distribute funds to creditors.
And liquidators have specific powers under the Corporations Act to gather information, including conducting compulsory examinations, which is how documents and testimony, like the Drew Davies interview transcript, are often obtained before litigation even starts.
Right, they can compel people to talk. Armed with the findings from his investigation, the liquidator, Henry McKenna, along with the company Alora Davies Developments 104 Pty Ltd in Lick, formally commenced legal proceedings.
They launched their action against the key individuals and the recipient entity: David Raphael, first defendant; Priscilla Raphael, second defendant; and Alora Property Group, Pty Ltd, APG, third defendant.
And the legal teams for this main fight.
Representing the plaintiffs, as we said, were Pinsent Masons as solicitors, with M. Davis as counsel.
Okay.
And the defendants, Mr. and Mrs. Raphael and APG, enlisted Wilshire, Webb, Staunton, Beatty lawyers as their solicitors, and I.J. King as their counsel.
Wilshire, Webb, Staunton, Beatty, and I.J. King for the defendants.
Right.
So these legal teams were locked in battle throughout the primary proceedings.
They were. The claims brought by the liquidator were extensive, typical of insolvency litigation. They alleged insolvent trading against the directors, arguing they allowed the company to incur debts like the Keishan loan when it was unable to pay its bills.
Okay.
They pursued voidable transactions claims, seeking to reverse payments or transfers, like that APG payment and the VPA transfer, that benefited related parties when the company was insolvent.
Makes sense.
And they claimed breaches of directors' duties, both statutory duties under the Corporations Act and general law duties, arguing the directors failed to act in the company's best interests.
So the stage is set for a major trial. But as often happens in high-stakes litigation, procedural battles can flare up before you even get to the core arguments.
This is where the drama really ramps up in the lead-up to the main event. We're talking about skirmishes fought over the rules of engagement that could significantly impact the trial itself.
The first, and perhaps most crucial from a legal precedent standpoint, was the battle over whether the liquidator had to comply with the expert witness code. This happened right during the main trial before Justice Black on 22 March 2024.
This is the battle that resulted in the key procedural ruling, now cited as 2024 NSWSC 335, and subsequently reported as 114 NSWLR 77. The defendants, the Raphaels, represented by Wilshire, Webb, Staunton, Beatty, and I.J. King, saw an opportunity in the liquidator's evidence.
Right. They argue that Mr. McKenna, in his affidavit, was giving evidence based on his professional expertise as an insolvency practitioner. He was analyzing the company's books, drawing conclusions about its solvency, detailing the findings from his investigations.
Essentially, they argued he was acting as an expert witness.
And if he was acting as an expert witness, they contended, he had to follow the strict expert witness code of conduct.
Right. This code, embedded in New South Wales's Uniform Civil Procedure Rules, specifically Rule 31.23 and Schedule 7, places an overriding duty on an expert witness to assist the court impartially, regardless of who is paying them.
The defendant's sharp argument was, how can a liquidator, who is the plaintiff actively suing us to recover money, possibly be impartial in the way the code requires?
Yeah, his role inherently involves advocating for the creditors by pursuing claims. Therefore, they argued his evidence should be inadmissible because it didn't comply with the code.
It was a clever legal tactic, wasn't it? Trying to use a rule designed for independent, third-party experts to undermine the very foundation of the liquidator's case, his own investigative findings.
A very clever tactic. But Justice Black, presiding over the trial, delivered an ex tempore decision on this point. That's an oral judgment given on the spot, though later refined in writing. And his reasoning focused surgically on the precise wording of the UCPR rules.
Okay, what did he focus on?
He looked closely at the definitions. While UCPR Rule 31.118 defines an expert as someone with specialized knowledge, which Mr. McKenna clearly has.
Sure.
UCPR Rule 31.23, the rule that mandates compliance with the code, applies only to an expert witness.
And the crucial part of the definition for an expert witness in the rules
is that it's an expert who has been engaged or appointed for the purpose of providing expert testimony in the proceedings.
Engaged or appointed for that purpose.
Exactly. Justice Black found that Mr. McKenna didn't fit that definition. He wasn't an expert who had been separately engaged or appointed by himself or anyone else specifically to provide expert evidence to the court in the way that phrase intended.
Right.
He was giving evidence in his capacity as the plaintiff, detailing the results of his statutory investigations and the conclusions he drew in that statutory investigative capacity.
It's a distinction that really highlights the unique position of a liquidator, doesn't it? They're statutory office holders conducting investigations as part of their role, not merely external experts hired to give an opinion for litigation.
Absolutely. So the ruling was clear. The expert witness code did not apply to Mr. McKenna's affidavit evidence in this context, and his evidence was admissible. The defendant's challenge failed.
This decision, 114 NSWLR 77, was a really significant clarification for insolvency practitioners across Australia, I imagine.
Huge. It affirmed that liquidators can generally present their investigative findings directly without jumping through the hoops of the expert witness code, which could otherwise make litigation much slower and more expensive, ultimately hurting creditors. It essentially said, the liquidator's evidence comes from their statutory job, not from being a hired expert witness for the case.
Okay, so that procedural battle was won by the liquidator, but there was another one brewing around key evidence.
Yes, Battle 2. the Drew Davies transcript privilege fight, which went before Justice McGrath and is reported as 2024 NSWSC 421. This also happened while the main trial was ongoing before Justice Black.
Right. The background here is that Drew Davies, that former director who had settled with the liquidator,
was now a witness for the plaintiffs. The liquidator's legal team, Pinsent Masons, represented by M.R. Davis, had privately interviewed him back in January 2022 as part of their investigation.
and the defendants, the Raphaels, still represented by Wilshire Webb Staunton Beatty with I.J. King, wanted access to the transcript of that interview.
They clearly hoped it contained something useful for their defense.
But the plaintiffs objected, claiming legal professional privilege over the transcript.
Standard argument. They argued the interview's dominant purpose, the main reason it was conducted, was for the liquidator to obtain legal advice regarding potential claims against the Raphaels and to formulate their litigation strategy. That's a standard basis for claiming privilege under Sections 118 and 119 of the Evidence Act.
But the defendants tried to get around this privilege using a specific provision in the Evidence Act, Section 125. What does that do?
Well, Section 125 says privilege can be lost in certain circumstances, including if the communication was in furtherance of a deliberate abuse of a power.
A deliberate abuse of power. Okay.
Yeah.
And what did the defendants say was the abuse here?
This is where it gets interesting. The deliberate abuse of a power they pointed to was based on one very specific detail. An email sent by the liquidator's solicitors arranging the interview with Drew Davies.
An email.
Yeah. That email, from 16 November 2021, proposed conducting the private interview pursuant to S. 597 of the Corporations Act 2001.
Here. Section 597D. What's the issue with that?
The critical point seized upon by the defendants is that Section 597 of the Corporations Act does not actually exist. It's a phantom section.
Oh, that's awkward.
Very. So the defendants argued that referring to a non-existent statutory provision in that email was evidence of a deliberate abuse of power, that the liquidator was trying to conduct an examination or interview under the guise of a legal power he didn't possess, thereby abusing his statutory position as liquidator.
Okay, I see the argument. How did that play out?
This application was heard by Justice McGrath on 8 April 2024. Justice McGrath's reasoning focused on whether there was sufficient prima facie evidence that, on its face, looks strong enough to suggest of a deliberate abuse of power.
Right. Not just a mistake, but deliberate.
Exactly. He noted that for privilege to be lost on this ground, it often requires showing the party knew they were acting improperly. And simply referring to a non-existent section in an email wasn't enough, especially since the interview that actually took place was a private interview, not a formal statutory examination conducted under that phantom power. Furthermore, the liquidator hadn't been cross-examined about why that specific section reference was in the email. Maybe it was just a typo.
Right. Could have been an honest mistake.
Possibly. So Justice McGrath found there wasn't sufficient prima facie evidence of a deliberate abuse of power. He declined to order the production of the transcript, upholding the liquidator's claim of legal professional privilege.
Another win for the liquidator on procedure. And the defendants.
They were ordered to pay the plaintiff's costs for this failed application. So the liquidator won this procedural skirmish as well.
With those significant procedural hurdles cleared, the main event could finally reach its conclusion.
Exactly. Let's move to the core of the matter. The substantive trial and the judgment in the main proceedings. The hearing of the liquidator's claims against David Raphael, Priscilla Raphael, and APG took place before Justice Black in the Supreme Court of NSW.
The trial spanned several days across March and April, 2024 specifically, 2022 March, and then wrapping up on 9/10 and 23 April.
And the same legal teams remained in place. Pinsent Masons with M. Davis for the plaintiffs, and Wilshire Webb Staunton Beatty with I.J. King for the defendants.
And on 10 May 2024, Justice Black delivered his detailed and comprehensive judgment, 2024 NSWSC 547. This is where the court laid bare the reality of the company's collapse and who was held accountable.
Let's break down the key findings. The first major finding, and arguably the most impactful personally for one of the defendants, was about Mrs. Raphael's role.
Yes, the finding that Priscilla Raphael was a de facto director.
This was absolutely central to the liquidator's ability to pursue claims against her for things that happened after her formal resignation. The liquidator's argument was clear. Despite stepping down officially in January 2018, she remained the person effectively running the show at a high level, particularly for the critical Tom Moore project.
They argued she was directing affairs, making key decisions, and was perceived by others, including statutory director Drew Davies and external parties, as being in charge. Her defense was that her extensive involvement was merely as an employee of APG, the company supposedly managing the project.
But Justice Black looked past the formal titles and applied that substance over form approach. He found decisively that Mrs. Raphael was a de facto director of Alora Davies 104 under Section 9BI of the Corporations Act for the relevant period after her formal resignation.
And he detailed why, based on her actions.
Yes. He found she had significant ongoing responsibility and directed critical development activities with very little actual oversight from the formal directors like Mr. Raphael and Drew Davies. The court said that even if she was also acting for APG, that didn't stop her from simultaneously acting as a de facto director of Alora Davies 104.
Wow. This finding was massive because it brought her within the scope of director duties and potential liabilities for actions that occurred after she was formally off the hook.
Huge implications. It's a massive warning sign for anyone who steps back from a formal role but continues to exert significant control over companies' affairs. The court will look at what you do, not just the title you hold.
And, as we touched on earlier, Justice Black specifically noted that her evidence lacked credibility unless it was supported by other evidence, particularly contemporary documents and Drew Davies' testimony, which painted a different picture of her role.
Right. Moving on to the insolvent trading claim, which centered on the Keishan loan.
The liquidator alleged that Mr. and Mrs. Raphael allowed Alora Davies 104 to incur a $300,000 loan from a party named Keishan on 11 June 2019, at a time when the company was already insolvent.
Justice Black agreed with the liquidator's assessment of the company's financial state. He found the company was insolvent from at least 17 May 2019. The key factor was that $479,400 Hammond loan falling due on that date.
Right.
The court concluded that, looking at the commercial reality, Alora Davies 104 couldn't pay its debts as they fell due on or after 17 May, including when the Keishan loan was taken out shortly after.
Mr. Raphael was a statutory director, and Mrs. Raphael was found to be a de facto director during this crucial period. They were the directors who were in charge when the Keishan debt was incurred.
And Justice Black found they failed to prevent the company from incurring that $300,000 debt at a time when there were reasonable grounds for them to suspect the company was already insolvent or would become insolvent by taking on that debt.
This failure meant they breached their duty under Section 588G of the Corporations Act, the core insolvent trading provision.
Correct. Both Mr. and Mrs. Raphael were found liable for insolvent trading. The damage caused to the company by incurring this debt when it couldn't pay its bills was assessed at $300,000, the full amount of the Keishan loan.
So the court ordered Mr. Raphael to pay $300,000 to the company, and similarly ordered Mrs. Raphael to pay $300,000 to the company.
Ouch. Significant personal liability. Next, let's look at the voidable transactions, payments, or transfers that the liquidator sought to reverse. The first was the APC 11 July payment.
This was a transfer of $202,000 from Alora Davies 104 to APG on 11 July 2019. This happened very soon after the Keishan loan funds came in, and crucially, after the Tom Moore land contract had been terminated because the company couldn't afford it. The net amount claimed back after some later repayments was $75,757.48.
And the evidence from Drew Davies was particularly damning here. He testified that Mrs. Raphael had described this payment as a way to quarantine money from creditors.
Quarantine money, not a good look.
Not at all. Justice Black accepted this view. He found this transaction was two things under the Corporations Act. First, an unreasonable director-related transaction under Section 588 FTA.
Yep.
This applies when a company makes a payment to a related entity or person, like APG linked to the Raphaels, and it's unreasonable in the company's circumstances. Second, he found it was an uncommercial transaction under Section 588 FB.
Right.
This applies when a company makes a deal that a reasonable person wouldn't have entered into, given the company received no real benefit, and it was done when the company was insolvent. The finding was that this payment was made purely to shield funds from legitimate creditors.
And did the directors breach their duties here too?
Yes. The court found that Mr. and Mrs. Raphael breached their director's duties under Sections 180, 182 by allowing or facilitating this payment. It involved a clear material conflict of interest favoring a related company, APG, over the interests of Alora Davies 104 and its creditors.
So the outcome was that the transaction was declared voidable?
Correct. APG, as the recipient of the improperly diverted funds, was ordered to repay the net amount of $75,757.48 to the company under Section 588 FF. That's the provision allowing liquidators to recover property transferred in a voidable transaction.
Okay.
And on top of that, Mr. and Mrs. Raphael were each ordered to pay compensation of $75,757.48 to the company under Section 1317H for their breaches of duty related to this payment.
So they were hit personally for letting it happen, as well as APG having to pay it back.
Exactly. Double recovery isn't allowed, but it holds both the recipient and the directors accountable.
Then there was the VPA transaction involving the valuable rights under the voluntary planning agreement.
This is perhaps the most, egregious example of asset stripping found by the court. Alora Davies 104 held valuable contractual rights under the VPA for the Tom Moore development. When Alora Davies 104 couldn't buy the land, a new party, REW 21, stepped in and bought it.
Okay.
REW 21 needed those VPA rights transferred via a novation deed to proceed with the development.
And here's where it gets really shocking. REW 21 paid $275,000 for those rights, including GST, to the real estate agent involved, Response Real Estate.
Right. Response Real Estate then paid $271,840, the net amount, to APG.
But Alora Davies 104 owned the rights.
Exactly. Alora Davies 104, the company that actually owned the valuable VPA rights that were transferred, received precisely nothing.
Nothing? How did they explain that?
Drew Davies' testimony was critical here again. He told the court he signed the novation deed only after Mrs. Raphael and others told him the VPA was a liability, and crucially, that no money was being exchanged for it from REW 21.
Which was completely untrue.
Completely contradicted reality. Mrs. Raphael's own affidavit gave two inconsistent accounts of the transaction, and an email from REW1 solicitor showed REW 21 clearly understood they were paying $275,000 for the VPA rights.
So Justice Black found this was
plainly an uncommercial transaction under Section 588 FB. Alora Davies 104 transferred valuable contractual rights that an arm's-length purchaser was willing to pay $275,000 for zero consideration. The money REW 21 paid for the rights was improperly diverted to APG, disguised as a sales commission or similar fiction that had nothing to do with Alora Davies 104 actually selling anything or receiving value.
And the director's duties again?
Mr. and Mrs. Raphael were again found to have breached their director's duties, sections 181, 182 this time, by allowing or facilitating this blatant transfer of value away from Alora Davies 104 and its creditors to a related party, APG. Justice Black found Mrs. Raphael knew the true nature of the transaction and the payment going to APG, and inferred Mr. Raphael also knew. This involved a clear conflict of interest.
Just like the APG 11 July payment, this transaction was declared voidable.
Absolutely. APG, as the recipient of the $271,840 that should have gone to Alora Davies 104, was ordered to pay that amount back to the company under Section 588 FF. And Mr. and Mrs. Raphael were each ordered to pay compensation of $271,840 to the company under Section 1317H for their breaches of duty in relation to this transaction. Again, personally accountable for allowing this asset to be effectively given away to benefit APG.
That's a huge amount. Finally, there were claims related to some Menangle payments made to MP1, another related entity where Mr. Raphael was a director.
Yes. The liquidator also sought to recover these payments and claimed director's duty breaches. While the payments themselves were found to be voidable transactions against the recipient, MP1, which had actually settled its claims.
MP1 settled, okay.
The claims against Mr. and Mrs. Raphael for breaches of duty, specifically regarding these particular payments, did not succeed.
Why that?
Because the court found insufficient evidence of their direct involvement in initiating those specific Menangle payments, even though they were directors and the payments went to a related entity. This shows the court was looking for clear evidence linking their directorial actions or inaction directly to the specific payments being made. It wasn't enough just to be a director when it happened.
Interesting. So the main judgment in 2024 NSWSC 547 resulted in significant personal liability for both Mr. and Mrs. Raphael for insolvent trading and breaches of duty, and orders against APG to repay the voidable transactions it received.
A major win for the liquidator on the substantive claims.
But even securing that win on the substance of the case wasn't the absolute end of the legal battle. The parties then had to fight over who pays the considerable legal bills.
Precisely. The fight over costs. This led to a separate judgment focused solely on legal costs. 2024 NSWSC 735, delivered on 18 June 2024.
And the plaintiffs, the liquidator, and the company weren't just asking for their standard legal costs to be paid.
No, they applied for indemnity costs from the defendants, the Raphaels, and APG, which is a much higher rate of cost recovery than the usual ordinary basis. You get almost all your costs back.
What was their argument for that?
Their argument for indemnity costs was that the defendants had behaved unreasonably by rejecting several settlement offers made by the plaintiffs earlier in the litigation. These included a pre-litigation demand back in October 2022 and formal settlement proposals known as Calderbank offers made in October 2022 and March 2024.
Okay.
They argued that the judgment they ultimately obtained was significantly more favorable to them than what they had offered to settle for, demonstrating the defendants' unreasonableness in not accepting.
That sounds like a standard argument for indemnity costs. How did the defendants respond?
They pushed back hard, arguing that their rejection of those earlier offers wasn't unreasonable at the time.
And their key reason
was that the plaintiffs had significantly changed the formulation and scope of their case late in the proceedings. They pointed specifically to the VPA transaction claim, which ended up being a substantial part of the plaintiff's success.
Right. The $271,840 claim.
Exactly. They argued it was not unreasonable to reject settlement offers when the case being prosecuted against them at the time those offers were made was materially different from the case they ultimately had to defend at trial. The goalposts had shifted, essentially.
And how did Justice Black see it?
In his cost judgment, he agreed with the defendant's perspective on this point.
Really?
Yes. He reasoned that the late amendment to specifically pursue the VPA claim in the way they did was significant. He found it was not unreasonable for the defendants to have rejected the settlement offers made before this critical amendment fundamentally changed the landscape and the potential exposure they faced.
Okay.
The plaintiffs hadn't shown that the rejection of those earlier offers was unreasonable in light of the case as it stood at those times.
So the outcome was that Justice Black refused the plaintiff's application for indemnity costs.
That's right. He also refused their application for a gross sum costs order, basically asking for a lump sum payment for costs, because he found there wasn't enough clear information to fairly calculate a lump sum, and there were complexities in allocating costs across different claims and different defendants.
So what was the final order on costs?
The final order was that the defendants, Mr. Raphael, Mrs. Raphael, and APG must pay the plaintiff's costs, but only on an ordinary basis. The exact amount would either be agreed between the parties or formally assessed by the court if they couldn't agree.
This costs judgment is a really practical lesson for anyone involved in litigation, isn't it?
Absolutely. It underscores that the reasonableness of turning down a settlement offer is judged based on the state of the pleadings, the evidence, and the known arguments at the precise moment the offer is made. If the case against you changes significantly after you've rejected an offer, that change can justify your earlier rejection and potentially save you from paying costs at the higher indemnity rate.
So that takes us through the whole dramatic procedural journey, from the initial planning dreams through the financial collapse and liquidation, the appointment of the liquidator, the commencement of proceedings, the intense procedural battles over evidence, rules, and privilege, the substantive trial unpacking voidable transactions and directors' duties, the significant findings of liability, and finally, the fight over who pays the legal bills.
Quite a roller coaster.
So what does all this actually mean for the world beyond this specific case? What are the big takeaways, the impact this saga has left on Australian legal practice?
Well, this series of judgments, particularly focusing on NSWSC 335, that's 114, NSWLR LR 77, NSWSC 547, and NSWSC 735, offers crucial lessons and clarifications, especially in the context of corporate insolvency law.
The most significant point of legal precedent, as we discussed, comes from that procedural ruling on liquidator evidence, 114 NSWLR 77.
Absolutely. That ruling is a major clarification for how liquidators can present their cases. By meticulously examining the definition of expert witness in the court rules and emphasizing that a liquidator's evidence stems from their statutory role in investigations as a party rather than being an expert specially engaged or appointed for the purpose of providing expert testimony.
Right.
Justice Black clarified that liquidators are generally not required to comply with the full, strict expert witness code formalities when giving evidence based on their investigative findings.
This has a huge practical impact for insolvency practitioners, I'd imagine.
Massive. It validates their ability to present their core findings efficiently without the added expense and complexity of hiring a separate expert witness to essentially repackage their own work. Legal commentators, including the liquidators firm Pinsent Masons, have highlighted that this decision should help deter defendants from using this specific type of procedural challenge, which has often been seen as delaying tactics that cost creditors money.
So streamlines things a bit.
It should. It reinforces the unique position of a liquidator's evidence, sometimes called sui generis, and makes it clear that While concerns about a liquidator's independence, given they are pursuing claims, are valid,
Sure.
those concerns typically go to the weight the court gives the evidence, not whether it's fundamentally admissible, particularly when the code doesn't apply.
Now, it's important to remember that even without the full expert witness code rules, liquidators giving opinion evidence must still follow the basis rule.
Absolutely. They have to clearly explain the factual basis and assumptions behind any opinions they state to ensure that part of their evidence is admissible and understandable. You can't just state a conclusion.
And because the definition of an expert witness in court rules is similar across most Australian jurisdictions, this reasoning could be influential beyond New South Wales.
That's the thinking.
Yeah.
It's seen as an example of the judiciary applying practical common sense to balance the need for procedural fairness with the practical realities and economic needs of recovering funds for creditors in an insolvency. Judicial pragmatism, you might call it.
Okay. Beyond that specific point, the main judgment in NSWSC 547 offers some really powerful reminders about corporate accountability.
Definitely. The findings on Mrs. Raphael's de facto directorship are a prime example. This case strongly confirms that courts will always look at the substance of what a person actually does to determine if they were acting as a director, irrespective of formal titles or formal resignation dates.
Substance over form.
Exactly. If you're exercising top-level management functions or directing significant affairs, especially with minimal oversight from formal directors, you can absolutely be held accountable as a director.
And the court's findings on the voidable transactions, the APG payment and the VPA transaction, and the associated breaches of directors' duties send a very clear message.
They really do. They highlight the severe consequences of using company funds or assets to benefit related parties when the company is in financial distress. It shows how directors can be held personally liable for the damage caused by these breaches under Section 1317H.
That personal liability point is key.
Even when the recipient of the funds, like APG, is also ordered to pay the money back under Section 588FF.
This powerfully reinforces the fundamental obligation directors have to act in the company's best interests. And crucially, when the company becomes insolvent, those interests shift to prioritize the creditors.
Right. Diverting assets to benefit related parties instead of preserving them for creditors is a clear breach with significant personal cost implications.
And of course, the court's detailed findings on Mrs. Raphael's evidence being unreliable are a stark reminder of the absolute necessity of giving truthful and consistent testimony in court, particularly when contemporaneous documents or other witnesses might contradict you. Credibility is everything.
Absolutely critical. Finally, the cost judgment in NSWSC 735 provides some important practical lessons for anyone involved in litigation and settlement negotiations.
It does. It underscores the importance of the timing and content of settlement offers relative to how the case is developing.
Yeah. A significant change or refinement in the way a party's case is pleaded after an offer has been made can be a valid reason for the other side to have rejected that earlier offer, potentially saving them from paying costs at the higher indemnity rate. It's a reminder to keep your settlement offers updated as your case evolves, or at least consider the risk if you don't.
Makes sense. So we've journeyed through the ambition, the financial failure, the appointment of the liquidator, the intense legal battles over procedural rules, including that key point about liquidator evidence, the deep dive into the company's transactions and who was responsible for them, and even the final fight over legal costs.
It's been quite the journey, covering a lot of legal ground.
This deep dive shows us that in the intricate world of corporate finance and law, the lines between formal roles and actual influence can be blurry, and the courts are willing to look at substance over form with very real and significant consequences for those involved.
It's provided important clarity on procedural points for legal practice, making the difficult job of liquidators pursuing recovery for creditors, well, maybe a little smoother by validating how they can present their core evidence.
But perhaps the biggest takeaway for you, the listener, whether you're running a business, advising one, or just curious about how these things play out, is the powerful reminder of the weight of directorial duties, whether you hold the title formally or are acting as a de facto director.
Yes. As this case demonstrates, the court will look at your actions, your knowledge, and whether you acted for the company's benefit, particularly for its creditors when times were tough, or allowed assets to be improperly diverted.
This saga wasn't just about recovering funds. It was a crucial clarification of fundamental principles about transparency, accountability, and the limits of using corporate structures to benefit related parties or for personal gain. especially when a company is failing.
Absolutely. The duties are real, and the consequences for breaching them can be severe, as the Raphaels found out.
Here's a final provocative thought for you to consider. In today's increasingly complex business landscape, where ownership structures can be layered and titles can sometimes hide who's truly pulling the strings, how effectively does the law, as illustrated by cases like this, ensure that responsibility for corporate failure ultimately rests with the individuals who are genuinely in control and making the key decisions?
That's a really interesting question. This case offers powerful insights into how the legal system is trying to address exactly that challenge, looking beyond the labels to the reality of control. But is it always enough? Something to ponder.